Today we're speaking with Cameron Kelly. He's a special counsel here at DibbsBarker in Sydney. Cameron, thanks for joining me.
David, pleasure.
Cameron, Australia's carbon pricing mechanism will have survived for just over 1 year come election day in September this year, and with the opposition leader Tony Abbott promising to repeal the carbon price if elected, and given his current lead in the polls, do you think the carbon price is effectively on borrowed time?
Well, David, it's the $64,000 question, isn't it? There's no doubt the current polling and what it suggests, and we're looking at about 30 weeks between now and the date of the election. The polling is probably likely to continue, in which case that puts Tony Abbott as the new Prime Minister come September 14. Given that the balance of power in the Senate remains or is likely to remain with the Greens, you're looking at a situation where Tony Abbott would need to go down the path of a double dissolution, as he's often suggested he would. That process is both lengthy, it's complicated, and the result of that is entirely uncertain. Even if Mr Abbott was to secure a return to government after the double dissolution process, he would still need to obtain a majority in the Senate to actually pass the repealing legislation. In terms of timings, you're looking at least 8 to 14, perhaps even longer, months. So you're looking at a possible repeal date of at least the second half of 2014. Now, bear in mind at that time, the carbon price has been in effectively for almost 2 years, perhaps even longer. We've seen that the results of the CPI and inflation suggests that the effect of the carbon price is pretty minimal. That's unlikely to change. So who knows how the electorate's going to vote on this come 2014, given those sort of market dynamics where the carbon pricing mechanism is really not affecting the electorate to that great extent.
Well, just let's assume that the coalition is able to secure a Senate majority, double dissolution or otherwise, and repeals the Clean Energy Act. What happens to the carbon units? I mean, will businesses be compensated?
Yeah, David, you're asking the tricky questions this morning. That again, it's a difficult question because it turns on not so much on the nature of carbon units as property. I mean, they are undoubtedly property. They're capable of being owned, transferred, assigned, mortgaged, so they undoubtedly constitute property. And indeed, the Parliamentary Secretary for Climate Change, the former Parliamentary Secretary for Climate Change, Mark Dravis, has always classified them as personal property. Where the issue becomes complicated and the legal waters get murky is, does the extinguishment of rights or does the repeal of those carbon units amount to an acquisition of that property by the Commonwealth under Section 51 of the Constitution? Of course, opinions in that score are entirely divided at this stage. You would have seen even an article in the Herald this morning which talks exactly about this issue. Certain companies in Tasmania are already suggesting that the flow-on effects of carbon price compensation has had a significantly advantageous effect on schooling and policing and education in places like Tasmania, and so they would be demanding compensation in the event of a repeal. So really, to just simply say that the repeal of the carbon price would lead automatically to compensation is entirely inaccurate, and I think, quite frankly, it would end up in some sort of constitutional challenge in the High Court.
Well, just finally, is it too early for business to make a call one way or the other and let business run just as usual, or should they be taking some preemptive action now based on the possible repeal of the carbon price?
So I've always been asking, I've always been advising my clients on this score to really act as though the carbon price is in, it is in, and to assume that it will remain to be in for the foreseeable future. So that means that it is very dangerous to comply with certain aspects of the legislation and choose to ignore others. A prime example of this is less than half of the liable entities at the moment have set up an emissions registry account under the relevant legislation to accept and trade in carbon units. They need to do that by June 15, but we have less than half of them who've already done that. The problem is, if we come to June 15 and those entities are unable to acquit 75% of their obligation, then they run the real chance of incurring a 30% surcharge, the shortfall. So really, quite apart from those sort of penalty regimes that kick in on the basis of companies that are choosing to ignore the pricing regime, there are in fact at the moment a number of significant advantages in becoming involved, particularly in terms of offshore carbon units and acquisition of those carbon units, which at the moment are at extremely attractive prices. So I'd suggest organisations, rather than just turning a blind eye to it, they really should be looking at how can they get involved at the minimum cost just to comply with the obligations.
Well, Cameron, thank you again for your insights this morning.
Thanks, David.